Okay, welcome to our live stream. My name, as many of you know, is Brian Horlick, condominium lawyer with Horlick, Levitt, Lella. So first of all, thanks a lot for joining us. Again, why are we doing what we're doing? When the COVID-19 pandemic started, we thought it would be a good way to keep in touch with all the condominium managers and the directors that we deal with and that we might want to deal with and some that we might not want to deal with. But good idea to keep in touch so that we can all be together and go through things that are important to everybody. So, as you know, we deal with condominium law. We have many people that are watching our live stream, and we do this. It's called an AMA, Ask Me Anything, and everyone's entitled and encouraged to type in questions, and we'll try to answer them to the best of our ability. To go through our schedule here, Mondays we normally send out a COVID-19 FAQ, frequently asked questions, and we totally update the latest news on COVID-19 from all of our sources. We back everything up with footnotes from those sources. So look forward to our email blasts on Mondays. Wednesdays, which are today, every Wednesday at 12 o'clock noon, we do something called AMA, Ask Me Anything. Again, it's the opportunity of board members and managers and others, unit owners as well, to ask questions that are relevant not only to COVID but to anything related to condominium. We started something new. Every Friday at around 12 o'clock noon, we have something called Case Law Corner, and we do a short 2-minute video on a relevant condominium case, and we send out with that video a brief written summary so that we try to keep you up to date with what's going on in with condo cases. So that you know, we've now sent out 2 videos. The first video dealt with noise in condos and what was expected of a condominium corporation in investigating a noise complaint. So that's an interesting case. And Nguyen, one of our associate lawyers, that was her video, and I encourage you to go to our YouTube channel and to view the video. The next video was on water leaks, very prevalent in condominiums, especially high-rise. And Penny Bendel, another one of our associates, did that case. Now coming up Friday, Alex Etkin, one of our articling students, will be dealing with a lawsuit with respect to reserve funds and how a unit owner thought that he didn't have to pay them, and he didn't have to pay a special assessment related to reserve funds, and unfortunately the courts were not in agreement with him. I also want to do a shout out again to our Premier, Doug Ford, for his tireless efforts in trying to balance the health of Ontario residents, and now slowly but surely trying to reopen the economy in gradual steps, which are important to everyone. But by the same token, we have to keep a firm and a primary regard to people's health. So on yesterday, while everybody was busy with other things in the condominium world, the government was also busy, and they extended the emergency order to June the 2nd. So the emergency order, meaning all of the legislation with respect to essential services, no gatherings of more than 5 people, all of that type of thing has been now extended to June the 2nd. The other thing that happened yesterday while the government was busy at work was that they passed something called Bill 190, which is also known as COVID-19 Response and Reforms to Modernize Ontario Act 2020. And what that law has done, or is doing, by virtue of Schedule 5 to that piece of legislation, it has amended the Condominium Act, and the amendments are now in Part 4.1 of the Condominium Act. Basically, what the government has done is they've taken all of the most recent amendments to the Condominium Act with respect to meetings and notice of meetings and the ability to vote electronically, the ability to have virtual meetings. All of those most recent amendments have now been put from the Emergency Management and Civil Protection Act. They've now been put as a schedule, as a section 4.1 into the Condo Act. But just so that we all realize, this is just a temporary measure during the emergency period when COVID is prevalent. This is not anything that at the moment is going to be effective past the emergency order. So without further ado, we're going to take some questions. So we have a question here from Dorina. Hello, Brian. Can you provide updated / additional information regarding permission for suite renovations and construction projects? Well, I will first of all tell you, many of you will know that Doug Ford is making some announcements tomorrow. Now, we don't know if he will be starting the phase 1, quote unquote, reopening of Ontario tomorrow, or he will just be discussing that he will be one day going to phase 1. But as far as the issue of construction to condominiums, there is still in effect the order whereby residential renovations, if they have not been started by or prior to April the 4th, cannot move forward. However, if they have started, they may move forward. So if they were in progress from April the 3rd, they can. However, it is our position as condominium lawyers that condo corporations may make rules and policies which are appropriate for their community, for their corporations, and may be more strict than the emergency orders. So to answer your question, if you did not start your renovations prior to April the 4th, you cannot do them. If you did start your renovations prior to April the 4th, that would be something that the board may have a say in by way of a policy or a rule. Next question. Does it matter if the owner is doing the renovations themselves? Good question. The orders set out by the government with respect to work that can be done deal with workplaces. And it's not relevant whether you have a contractor in there or whether you have an employee doing the work. So the question is, can you do work yourself? I don't see, if you did some type of, minor work in your unit, I don't see that there would be a tremendous issue. Once again, the whole purpose of the emergency order is to reduce contact between people. So as long as you're doing something within your unit and you're not bringing in trades, that might be something that would be appropriate. Now, question here, if a corporation commissions work from a non-essential service provider when the emergency order is in place, would the corporation be subject to fines? So that's a good question, and that's something that we discussed 2 weeks ago. And the answer is there are provisions in the emergency orders, in the Emergency Management and Civil Protection Act. There are specific provisions there for fines and penalties. The fine for a condo corporation that breaches the Emergency Management and Civil Protection Act is for an individual person $100,000. For an individual who is a director, it's $500,000, and for a corporation, it's no more than $10 million, plus imprisonment for a year or more. Sorry, for not more than a year. You're saved over there. It's unlikely, of course, that the fines would reach the level of the maximum, and it's unlikely that a board member or an individual would face heavy fines and imprisonment, but there is substantial legislative power here. When you breach the Civil Protection Act, it's a serious issue. So I'm not counseling those boards and who are under pressure. And condo boards today are under pressure from not only their unit owners, but they're under pressure from contractors who want to move forward to do their jobs. And I understand that because there's an economic impact when the contractors cannot move forward with their jobs. I understand this, but again, the emergency order was put in place to assist in the COVID-19 epidemic, and there's a reason that those prohibitions are in place. I think what we need to do is we need to concentrate on the big picture, and if the economy opens up in the next few months, and again the government is looking carefully at the economy, they're looking carefully at the numbers with respect to how many people on a daily basis are getting sick, and how many people are attending for going in for testing and are okay or not. It's important that we keep health and safety primary. Economy is very important too, but there's no point to have a good economy if you're not around to see it. I hope I answered your question. Here's a question here. What are some legal issues, if any, that you may have encountered regarding vacant land condo corps? So this is an interesting question as well. Vacant land condo corps are unique in that you have a condominium corporation, and the condo corporation or the condominium corporation is registered before the building goes up, and that's why it's called the vacant land condo corps. And you therefore you will build on your unitized lot after the condo corp is registered. Usually in condominiums, you're going to have a condo that's going to go up first, and you're going to have the property built first, and then the condo corporation becomes registered. The only thing that's unique there is that most of the vacant land condo corps deal with single family homes. You're not going to find normally a high-rise building or a townhouse on a vacant land condo corp. You will find normally single family homes, and really and truly, again, the emergency orders have not really set out the uniqueness of that type of condo corporation, where you would think that if you have a single family home, you might be able to have some flexibility with respect to the emergency orders, but it's not the case because it hasn't been set out in a special manner. Here's another question here. Should we lighten restrictions for realtor showings at this time, or wait for Ford to announce that realtors may resume work? So as we all know, it's open houses that are prohibited by the emergency order. You cannot have open houses. You are allowed to have showings. That hasn't been prohibited by the emergency orders. Having said that, the Ontario Real Estate Association, or REA, and the Real Estate Council of Ontario, RECO, are strongly urging realtors not to do showings unless they are absolutely necessary. Again, the point is to try to market condominium units in a manner that doesn't have the same personal contact. Once again, trying to stop as much as possible the spread of the COVID-19 virus. So as we move forward, let us say into phase one of the government's plan, there will be an opening or a lessening of the restrictions. However, people still have to keep in mind that I would believe for quite some time to come, we will be dealing with the COVID-19 virus. And so I am personally not in favor of showings where you can have any time, 4 or 5 showings on a condominium property in a high-rise building, let's say, where people are coming and going. I don't think it's a very good idea. So I think, what we're suggesting is that if you have an agreement of purchase and sale that's conditional on an inspection, yes, the prospective buyer should be allowed to go view the unit. When you have an agreement of purchase and sale that has a right of inspection before closing, I agree that the prospective purchaser should be allowed to see the unit. But again, we need to use our common sense in everything that we're doing now. Here's another question here. Will we get a warning first, or will the inspector issue the fine right on the spot? Well, this is going back to whether, what happens if you have a trade person come onto your property as a condominium, and that trade person is not an essential service. You will likely either face a stop work order and or a potential fine. The inspector is not going to levy the fine. I believe this is under the Provincial Offences Act, and so you'll be left with a nice, probably a yellow piece of paper that is a summons to appear in the Provincial Offences Court, and from there you'll have to either plead guilty or not guilty, or say that you relied on your lawyer and he gave you a bad opinion. Maybe that'll help you. Next question here from Melody. What do we say to unit owners wishing for the amenities to be reopened? Some unit owners want to requisition a meeting to reopen the amenities for use on an individual sign-in basis. Well, Melody, I think what we have to do really and truly is follow the lead of the government. And when the government, who is in lockstep with the medical health authorities of the province, when they deem it safe to start loosening the restrictions, then I think it's appropriate to start loosening the restrictions. Now, what does that mean for amenities? Well, for example, if you have a gym, you may want to say, you will definitely need to limit the amount of people in the gym. You will definitely need to respect and observe social distancing, meaning that, the 6 feet between people, which would translate to at least, people being on the first treadmill and on the fourth, with the 2 in the middle being empty, sanitizing of all of your equipment after usage, an appropriate sign-in or reservation system. So these are all important things. I don't think as responsible board members, as responsible managers, we can allow ourselves to be bullied or pushed into doing things such as opening amenities too early. I think the risk is very grave. We are not out of the woods yet, and it may be some time until we are, although the weather's sunny now and supposed to be warm, but it's not. We are not where we want to be as far as COVID-19 being under control. It's not worth to have a problem. It's just not worth to have a epidemic within your building, sweeping your building. It's just not worth it. I know that we have been in touch with some commercial health clubs, big ones in Ontario. They're also waiting to get a signal from the Ontario government, and they're going to be using social distancing and sign-ins for their gyms as well. So, good question. Are you aware of any corporations that have been fined for breaching the emergency order? That's from Shelley Robinson. We are not. I think most corporations are adhering to the emergency order. I know that there are pressures again from trades, there are pressures from unit owners, open the amenities. We want to do our construction work, we want to do our windows, we want to do, all sorts of, we want to do our lobby. And again, this is understandable, but we are in a very unique and difficult time, and people need to respect the viciousness of COVID-19. It's an unforgiving disease, and it will not forgive you for opening up your amenities. It will not forgive you if you move forward and people, residents and owners get sick, and you will not be happy. Paulo, next question. Hi Brian, units are still being sold and new purchasers want to renovate the units prior to moving in, which is not an unreasonable expectation. What is your recommendation? Paulo, I agree with what you're saying. Owners are moving in, owners are moving out, and so there's trucks coming back and forth, and that's understandable. People have to move in and out. However, renovations must be put on hold. It's difficult for people to understand. Some people don't want to understand that. Some people don't want to accept that. I, as a resident, and I'm not, but if I was a resident or an owner in a condo, I wouldn't be very happy with somebody who bought a unit, wants to renovate their unit. All sorts of people are coming into the building, trades and contractors, to renovate that unit. And that person's okay because they're sitting somewhere else where it's nice and quiet and peaceful, and nobody's coming to their place, but everybody's coming into my building, and they're not worried because I'm the one who can get sick, not them. And when their unit is all finished and beautiful, and then they're going to come and live there. That's not acceptable as far as I'm concerned, and that's not acceptable, to the majority of condos. So, Paulo, my answer to you for those people is tough luck. Now, while we wait for some more questions to come in, I'm going to read out some of our fan mail, which we do every 2 weeks, because I only do this every 2 weeks. Bradley comes on every second week, and he doesn't want to read his fan mail, but I got to tell you, he's got lots of it. So we have one here from a condo manager, a senior manager at a condo corporation, at a management company, sorry. You are the best ever. I love watching your videos every Wednesday. Your no-nonsense way of disseminating information in such a way that we can all understand. Thank you, thank you, thank you. Please keep doing what you are doing. You are illuminating a lot of young minds out there with unbiased information that are getting into the business. So I thank you. Here's another one from the president of a management company. Knowledge is power. What you are doing is so fantastic. Kudos to you, Brian. Here's another one from a regional manager. Thank you for the information. I'll definitely share this with my team of managers and site administrators as well. I'll make a note at our next regional managers meeting. So, for those of you who want to see certain things on this live stream, send us an email. We're happy to accommodate everybody. We want to know how we're doing and how we can improve, because again, we're doing this for the community. So, some more questions here. This is going back to renovations on units. And the question here was dealing with noise disturbance while everyone is working from home. Well, that's one of the reasons, in addition to the spreading of the COVID epidemic, that's one of the reasons why we're suggesting strongly that renovations be stopped, whether it was, renovations that began before April the 4th or after. It's unreasonable to have tradespeople, and in some buildings that are quite large, you could have 5, 6, 7, 8 renovations going on at the same time. It would be unreasonable for people that are home every single day and working from home or retired to have to bear the brunt of the noise. Next question, Mr. Buckler. Is it reasonable for a corporation to limit unit access for showings such that only the realtor can view the unit not the clients, with the realtor only taking a video of the showing to show clients. I don't think that's reasonable. I think it's unreasonable to have showings at the moment, but I don't think it's unreasonable to have showings where you have a conditional agreement of purchase and sale conditional on an inspection. And the reason is to reduce the amount of people coming into the buildings. You don't want to have showings in general. We only want to have showings where somebody has already signed and they're interested to buy the property. Today, you can have many different ways to see a property, virtual showings. You can have it on your screen, on your computer, through way of pictures, through way of videos. You can have layouts. You can have everything you need. You don't actually have to go there. If you have all of that, you can make an offer on a condominium unit, and if you are successful with the price and the offer and the terms, you make sure that your offer is conditional on the inspection. You go in right away, you check it out. If you're disappointed in any way, which you should not be disappointed because you would have seen the entire video, then you can not waive your condition and you can move on. Lydia, next question. What if it is only one contractor coming into the building and using personal protective equipment? Again, you have to look at the list of essential services, and the orders are very clear. The orders allow for maintenance, repair, and property management services which are quote-unquote strictly necessary to manage and maintain the safety, security, sanitation, and essential operation of your residential property or building. Bottom line is, unless that service falls within that definition, you cannot have people coming in to do work in your building. Paulette Forsyth, more board members need to hear what you are saying. It's excellent information. Pauline, thank you very much. We appreciate your valuable comments. Olivia, I hope this live stream will continue even after the pandemic because this is our weekly routine now. Way to go, Brian and Brad. So Olivia, I will tell you this, that it takes time to prepare for these live streams. We have received a lot of positive feedback. I'm going to strongly recommend to the lawyers in my office that we continue this as we are doing every Wednesday at noon, not only until we beat COVID-19, but we continue doing them thereafter because I think it's valuable. Education and knowledge are key to successful condominium living, and if we can do something in a small way to assist that, we're happy to do that. Next question here. Is it reasonable to stop a unit from receiving visitors when they have not signed a COVID-19 declaration and cannot prove their visitation is essential? We do not believe that it is reasonable to stop visitors to a condo, whether they're essential or non. The government order was there should be no social gatherings of greater than 5 people, and that is the barometer by which we look at these things. So we don't say you need to sign a declaration. I think we have to, as a condominium industry, we have to educate. Most people are understanding COVID-19, but with proper signage at your concierge desk, with proper newsletters and bulletins to your owners, you have to educate people. But everybody knows that if you're sick, you shouldn't be going into the condos. But I don't think it's reasonable to stop people. Just to continue along that comment, there's been a lot of discussion recently. First, the discussion was, you don't need to wear a mask. Then the discussion was, well, if you're sick, you should wear a mask because you will prevent other people from getting sick. Then the discussion became, well, it might be a good idea for everyone to wear a mask. Going forward, we see that some of the food stores, such as Longo's, are now have a policy in place that you cannot shop there without wearing a mask. I understand that in the United States, Costco has adopted a similar policy. I can see as COVID continues that there may be retailers who will insist and make a policy that you cannot go into their stores without a mask. So the question then becomes, should unit owners / residents in condominiums be wearing masks on the common elements? And if the answer is they should be, the next question is, should they be required to be? And if they should be required to be, and it's not within the government order, the question then becomes, is what should condos do, or should condos do something to enforce the wearing of masks on the common elements? And if that's what a condo corporation or a board or a community feels is important, what is the best way in which to put such a policy into effect? And I'm going to suggest that as we move forward in this unique situation, condominium corporations may want to seriously consider that residents must wear or are highly encouraged to wear masks as they walk through the common elements. And if that is something that's really important to the community, serious consideration needs to be had by way of looking at a potential rule to insist that for health and safety, which is part and parcel of what rules are all about, that owners or residents or visitors are mandated to wear masks in the common elements. Now, I know that sounds maybe awful and terrible and radical and authoritarian, etc., but this is really something that as we're moving forward, I think that's something that is going to be a topic of discussion. Next. Melindo, in support of Olivia's comment, it has really become a weekly routine. This is awesome. Okay, we'll see you next time for lunch as well, Wednesdays. Robert, is it the corporation's duty to install high-end filter systems and HVAC equipment to prevent the potential spread of COVID, or is this unproven and unnecessary, especially if the costs are high and unbudgeted? I don't know any corporation that is upgrading their filter systems to deal with the spread of COVID, to deal with germs, etc. It's an interesting suggestion. I think right now it's in the it's an option if a corporation wants to do that. Some corporations are undertaking intensive deep cleaning. Others are just cleaning normally but regularly. I would suggest that in those condominiums where there is a large number of short-term rentals happening, which, by the way, short-term rentals under the City of Toronto's amended bylaw is any rental less than 28 days. So what we have seen happening in the marketplace is that as condo corporations began to attempt to enforce the government order, which said that short-term rentals are prohibited unless they're basically for housing purposes, meaning short-term rentals are prohibited for tourists, but are still available for housing. And the short-term rental, once again, it has to be 28 days or more. Many of the short-term operators have now taken the position that they are only renting for 28 days or more. That, in fact, is usually not the case. But in those situations, I would suggest that those unit owners who are doing short-term rentals, or even worse than that, those tenants who rent units and they do not advise the owner of the unit that they are in the short-term rental business, there could be a liability there for not doing a deep enough cleaning of their units, which really now are hotel units, and they are only hardly doing a surface cleaning job, and therefore, in my view, leaving open to unsuspecting occupants, short-term occupants, potential for picking up the unwanted COVID disease. Next question, Daniel. We need to perform our anchor 5 years load test and inspection before we can do the windows. At this time, can we request access to units? Daniel, I'm going to tell you that it's not a good idea. It's not a good idea. People do not want anyone entering their units. People are very apprehensive about the COVID-19. It is, again, a vicious disease. And the only time I would recommend allowing people in your unit is if the building was ready to fall down. I'm sorry. We had a wonderful president of a condominium corporation, a wonderful, hardworking president of approximately 50 to 55 years old, in perfect health. I'm going to use the past tense because unfortunately he passed away from COVID. It was a terrible thing. So it's much more than just reading about it in the newspaper. It can happen to every one of us. So let's be responsible. Lydia, is it reasonable to say no to renovation that requires minimum amount of noise if the owner is only wanting to sell because the owner lost their job and is in financial hardship, unable to pay common element fees? Lydia, this is like a law school question. I'm going to tell you, again, the issue of renovation is subject to the emergency order. And the emergency order says no. And as you know, no means no. Next comment or question here. The HVAC and building science industries are split on the issue of HVAC transmission of droplet-borne viruses. The most common statement is that it is like passing somebody on the street. Well, that's a very good comment. Again, we need to look to the experts in the business to assist us. And if the experts are saying that, it's not going to assist with respect to a, changing of your HVAC transmission issues, well, then you don't. But again, everything has to be cleaned appropriately, and my warning is for anybody, any condo corporation, any unit owner, any tenant doing short-term rentals, there's an issue right there. So we'll wait for a few more questions to come in. Now we have a subscribe button here on the YouTube channel, so if you could press it, you'd be able to be one of our subscribers, and we would be able to send you directly further information. If you are enjoying the live streams, I'm going to ask you if you could kindly leave a review and set out what if you're pleased with that. Again, this Friday we're going to have the case law corner, and we're going to be actually dealing again with a reserve fund issue where an owner decided that he did not want to pay the special assessment which was needed to fund the reserve fund. He then sued the condo corporation for oppression, and you'll see that case coming out on Friday. And it's a good case for condo managers and board members to see and to review. We also know that in every condo building, especially high-rise buildings, you will always have water penetration, you will have leaks. There are significant obligations on managers and board members to investigate those leaks, to get reports to see if it's a unit owner issue or a condominium corporation issue. The judges frown upon condo corporations, which at the first moment say it's not our responsibility, it's a unit owner responsibility. Tests need to be done in order to determine that. The water leak case that we did, that was the case that Paneet Bandel did last week. It's on our YouTube channel, and you will see where the court was not pleased with the behavior of the condo corporation, and there was a significant damage award against the condo corporation for their lackluster efforts in trying to determine where the water was coming from and ultimately putting the proper fix in order. Again, our first case that we did, which was Ann Nguyen, and Ann's case was on noise, and set out all of the procedures that boards need to take when they are faced with unit owners or residents claiming that the noise that is coming to their unit is undue. So that's very important as well. Next. The tenant left a unit in bad condition, and to sell it in this state will result in a much lower amount of money versus selling repaired and painted unit. Okay, Lydia, I've got an idea. Don't sell it now. Wait until the Ontario government opens up, and they will, the economy, and it starts to allow for renovations. That would be the time to get that unit fixed. And I'm not a realtor, but I'm going to suggest that now is not a great time to be selling in any event. Next, can you share the case with us before Friday so that we are better prepared to pepper you with questions? The answer is no. We don't. The case for Friday is not live stream. It's just a video. It's a 2-minute video that we send out, so you have the lawyer there discussing the case. And when we send you the link for the video, we also set out a written summary of the case for you. So it's good for you to keep, to review, to download it into your own library. Paulette, I have a question about a reserve fund. If the board decides to rework the study to add $400,000 to expenses, are they required to have a notice of funding completed, or at a minimum review it with the engineer? As soon as you're going to rework your study, you're going to have to send out a notice to your owners. You cannot change your reserve fund on your own. So if you think that you need further funds, you have to do that, or you should be doing that in consultation with your engineer. And if you're going to have to raise funds, you need to set it out in your funding plan, because your $400,000 is going to affect not only the year that you're doing it, but the entire table of funding. Next question. What are the impacts and risks of a board of directors sharing other board members' contacts without permission to residents and owners? What should be the consequence of this board member or other staff? So you're talking about sharing contacts without permission. I believe the contacts you're probably talking about are either phone numbers or emails. Clearly, unit owners are entitled to the record of the corporation, and that would be obviously the address for service, so, and the name of the owner. But you're not entitled to emails. You're not entitled to private information. Somebody's phone number is not part of the record. Somebody's email is not part of the record. Basically, what you're saying is there is a breach of privacy, or what's called an invasion of privacy. I would suggest that there's 2 issues here that you can look at. One issue is if this is a board member sharing other board members' information, my first question is, do you have a code of conduct that all board members are required to sign when at the moment they are elected? And if you do, that board member is in breach by virtue of divulging personal information. My next question would be, in your operating bylaw, do you have a provision there that if you breach your code of ethics on at least so many occasions, that is an immediate cause for disqualification? And lastly, of course, somebody can sue under the new tort, the new wrong. There's a new tort of invasion of privacy, which didn't exist in Ontario until the last 7 years or so. There's now something called an invasion of privacy, and if you invade somebody's privacy, they can sue you and you would be liable for damages. I don't think that the damages in this case would be significant. Next question. What if the board refuses to make it a requirement for unit owners to wear masks in common element spaces? Can management make it a requirement without their consent in order to protect staff? Well, Melody, I think this is going to be the next significant issue as we move forward with condos. The next significant issue is going to be masks. And again, should people be wearing masks in the common elements or not? Part of this is going to be what we see with the direction that the government will be taking us in. Part of it is science. Is it important to stop, the potential spread, the potential droplets in the air? Again, the government may highly recommend it. As I said before, retail stores, some of them are beginning to insist that if you're not going to wear a mask, you're not coming in. And so, we really need to think about condo corporations, because how can you appropriately be 6 feet away from somebody in the common elements? In certain condos, if you pass somebody in the hall, you're going to be less than 6 feet away. In certain condominiums, you're not going to have that luxury of 6 feet. And so the government is saying in those situations where 6 feet is not possible, you're highly encouraged to wear a mask. So I think what it's going to come down to is A, educating the residents in the condo, B, considering for those residents that refuse to wear a mask and don't see that it's important, condo corporations will have to consider whether the road to travel is passing an appropriate rule. So this is, I think, the next thing that boards and management are going to have to be sitting around and discuss. I think it's very important as we move forward. Jerry, do your comments pertaining to wearing masks on common elements also apply to vacant land condo corps, where common elements consist mainly of roadways and large gardens and physical distancing is practical? That's a very good comment. My comments on wearing masks really relate to the inside common elements of condo corporations. When you're outside and you've got the 6 feet, I don't see that it's going to be essential to wear the mask. It's really on the inside. So for vacant land condo corps, again, where it's mostly single family homes, I don't think it should be mandatory or a requirement, as long as you're keeping your social distance. Tova, what if the director refuses to sign the code of ethics? I'm going to say this. When we had the government hearings, the government was putting forward amendments to the Condominium Act. The government was putting forward licensing for managers. The government was putting forward the Condominium Management Services Act. And the government was setting out a code of ethics for managers. And that is fantastic because, as a licensed body, as most licensed bodies, if not all licensed bodies, there's a code of ethics. And when we were at the government hearings, I put forward a position to the government. I said, look here. I said, it's great that you have a code of ethics for managers, but managers are required to take instructions from board members. So therefore, it's very important that those that give the instructions, in other words, the board members, be also subject to a code of ethics. And unfortunately, to date, there is no government mandated code of ethics for anyone who wants to be on a board. And I think that's a real omission on the part of the government when they were making the amendments to the Condominium Act. So if you have in your qualifications, and that's where it should be, that when you're elected, you need to sign a code of ethics. If that's in your qualifications, you would have a similar disqualification section, which would say, and if you don't sign the code of ethics, you're immediately disqualified. There's super, super important obligations and duties on board members. And board members are obligated to act honestly and in good faith with proper care and consideration. These are mandated by the Condominium Act. Having said that, it's really important that every board member sign a code of ethics to govern himself or herself accordingly. You read too many horror stories and you hear too many horror stories of some board members who are on boards for reasons other than the best interest of the condo. Paulette, if masks become mandated in the common areas and condos, will the corporation need to incur that cost? Another good question. So I'm going to say this. The cost is going to be, I won't say negligible, but in the big picture of whether people get sick or stay safe, it's going to be a negligible cost. I'm going to suggest, as we move forward with this unfortunate COVID-19 situation, which I believe is going to go on for quite some time, maybe not in the same manner as it is today, maybe with some loosening of restrictions, but it's going to be going on for quite some time. I'm going to suggest that owners and residents and visitors be highly encouraged through education, through notices, to wear a mask in the common elements. And I'm also going to suggest it would be a good idea for the concierge to have nice little masks in packages to give out to the owners, and educate people in a nice way, however that may be, of the importance to do this. This is a community situation. Everybody living in the building is a community of residents, and everybody in the community wants to keep safe. You're only as safe as the most sick person in your building. So everybody needs to take care. Again, I'm not a doctor. Don't think I am. I'm a doctor of condo law, maybe. But you got to wash your hands all the time. And I think masks is the way to go. Next question. What would you advise the board if residents and owners want to talk or write to the board directly and not to management? Should the board establish their own email line to field those inquiries? Well, that's a fine question. We get that all the time. I think as an owner, you have the right, or you should have the right, to communicate in an appropriate manner with your board. And I don't see why it would be required that it has to be through the manager. Now, having said that, the manager is there and takes direction from the board. So nothing the manager is doing should be something that's of a surprise to a board. Now, the board members also have personal lives, meaning that they are allowed to live in the condo, live in their unit, enjoy their common elements without being inundated by questions from owners. Those questions should properly go to the manager, to the admin, because that's what they're there for. That's what the condo's paying these people for, is to manage the building. And part of managing the building is listening to owner issues. But having said that, I think there should be a line of communication in the event a unit owner wants to speak directly, to either attend a board meeting in person for to address some important issue, or an email should go in with whatever their issue would be. And those, I would say, would be special circumstances, not the everyday occurrence, because then again, who could be on a board, or who would want to be on a board if you got 30 emails from residents on a monthly or regular basis? Next, are there implications or liabilities in having a general board email available to residents to contact and for the board to reply? No, there's no liabilities or implications. As I said before, when your manager is moving forward with the management of the building, that manager is doing so pursuant to directives of the board. So no, there wouldn't be implications. Next question, Alexandra. In the circumstances we are in, how do we go about the numerous noise complaints about children playing in the units above, people talking, or just plainly living? Well, you should pass a rule saying that no one's allowed to live in the building, and that would make it real quiet. But seriously speaking, you have to investigate noise complaints. Now, I said before, 2 weeks ago, Ann Nguyen from our office did our first video for our condo case law corner on noise. And I'm going to suggest that you listen to that. But in that case, there is an obligation on the condo corporations to investigate the noise complaints and to deal with them. So whether they are noises from children, noises from jumping, these things have to be investigated, even to the point where if there is a question of whether the noise is legitimately sufficient to disturb people, sometimes there has to be a noise test done. And I will tell you this, that the courts frown on the position that some boards take, being, well, we're not going to pay, we'll pay for the sound test, but if the sound is deemed to be reasonable, then the complaining owner has to pay for the sound test. If that sort of sounds reasonable, but the courts don't like that. The courts want the condo corporations to pay for the sound test and to make the determination whether the sound is unreasonable or not, and then move forward. So it's something that you need to take seriously, because unit residents who are being disturbed by noise from whatever reason do have a right to quiet use and enjoyment, and there is an obligation and a liability on the condo corporation if those rights are not being respected. Next, from Melody, her noise complaints have tripled. From Paulo, lots of marijuana complaints as well. So what should you do, Paulo, about marijuana complaints? Marijuana complaints is a nuisance. It's odors, it's smoke, it's bothersome. It affects people's quiet use and enjoyment of their units. So just like sound, which a noise, which is a nuisance, the same thing goes with cigarette smoke, tobacco smoke, or cannabis. You need to take steps to investigate whether it's undue and unreasonable, and the condo boards, condo corporations have an obligation to do that. There's a liability involved if they take a position that it's not their business. Now we have just a few more before we wrap up. The use of a community software platform such as CondoLink allows for direct communication to the board in their separate inbox. Okay, so there you have it. You can, with certain community software, you can absolutely send an email to the board. And our last question from Gary. You don't need to pay for a sound test. I have an app on my phone that tells you how loud something is. Okay, well, Gary, that's great, but I'm going to suggest that that app is not going to stand up in court if you have to go to court because you've told an owner that the sound is reasonable and it's not. So maybe that is a first step to try that app on your phone, but you really need to use a scientific test. And Melody agrees with me and not you, Gary. She says that may question the validity of the test. But by the way, what's your app? So if you want to type in your app, everybody will know. Last question is coming in from, second to last question, from Alexandra. We usually investigate the noise issue, but it's hard to do during the pandemics. Well, absolutely it's hard to do. I will just tell you this as far as noise. I used to say noise was like a symphony. And it's like a symphony because, you know, when you have noise, sometimes there's a lot of pieces of equipment that are working together to muffle noise. And when those pieces of equipment are not working or not all working at the same time, you can hear the noise. So noise can be very elusive. Sometimes you hear it, sometimes you don't. And that could be because of other noises in the building. And again, sometimes you think it's coming from a certain unit, and in fact, it's not. It's coming from another floor and from a unit down the hall. So it's really difficult sometimes to find the source of the noise. Paulo, last question. We have multiple units smoking and it's hard to identify the cause. Would you be okay with using a canine to assist the manager ID the source? Paulo, I'm sure you used to work for border security, and that's why you know all about the canine when they were trying to sniff out the drugs. The question is this, by the way, that's a joke. You can use different type of things to find how the smoke is coming. I think it's a real problem if you have a lot of smokers in close proximity. It's a real problem to identify which one is the smoker who's causing, you know, most of the discomfort to other unit owners. But there are various tests that you could use to see how the smoke is penetrating through the walls. But again, as I said, sometimes it's very difficult if you have multiple smokers in a close area. But again, you do have that obligation to investigate it properly. Jerry, sorry. Not only are your presentations educational, your sense of humor is priceless. Thank you, Brian, and we'll see you next Wednesday. See you in 2 weeks, even if you don't play the sax for us. So there you go. That old saxophone is coming up again. So as you know, I'm a tenor sax player, and there's a lot of pressure on me. It's like the pressure of contractors who claim they're essential services, and they're not. So I don't know if sax playing is an essential service, and I don't know if I'm allowed to play on this live stream, but I'm going to consider that, Mr. Johnson, and thanks for bringing that up. So anyways, I want to thank everybody. We're at the end of the chat. We're back next Wednesday. Bradley Chaplick will be doing next Wednesday's chat. Again, if you enjoyed our live stream, I'm going to ask if you could kindly leave a review and click on the bottom of the screen there. And again, look out for our cases coming out every Friday. And Doug Ford is moving ahead tomorrow with further information on opening up the economy. So be sure to read our updated COVID-19 FAQ, which is going to be coming out on Monday. I want to thank everybody for their time. I want to thank everybody for coming out and listening to the live stream and asking your excellent questions. We'll see you next week, and have a safe week. Thanks so much.